5 more SEC attorneys confront bar complaints tied to Jorge Tenreiro controversy. Veritaseum's motion to vacate set to surpass Debtbox, exposing stunning SEC misconduct under Berger's watch. The recent demotion of Jorge Tenreiro from Chief Litigation Counsel to the IT Department, following 180-plus bar complaints lodged with the New York Attorney Grievance Committee, or the AGC, by the Veri community in October 2024, has triggered a wave of additional scrutiny. On April 7, 2025, 5 further complaints were filed against SEC lawyers implicated in what is alleged to be a fabricated case targeting DeFi founder Reggie Middleton, patent number US 11196566, and his companies collectively known as Veritaseum. The additional bar complaints were filed against Mark P. Berger, and this is a link to his complaint here, director of the SEC's New York Regional Office, left the SEC in 2021 to become a partner at Latham & Watkins LLP. Lara Shalav Maraban, and this is a link to her complaint here, Associate Regional Director of the SEC's New York Regional Office, left after 15 years at the SEC, becoming a partner at Sidley Austin LLP. Victor Suthamanant, and this is a link to his complaint here, SEC Lead Attorney, left the SEC in December 2024 to become a partner at Castellanettes LLP. Karen Willinkin, and this is a link to her complaint, SEC General Counsel, and John O. Enright complaint, Cyber Unit and SEC General Counsel. On March 13, 2025, a letter from Middleton's attorney Jason Siebert highlighted a discussion with counsel for the SEC in which they stipulated a stay in the Consolidated Final Accounting Report discharging the distribution agent, terminating the Fair Fund and related relief, pending the outcome to a motion to vacate alleging fraud upon the court, per Federal Rules of Civil Procedure 60D3. And this is the letter here, and actually there is a proposed schedule, proposed briefing schedule for a motion to vacate the consent order and judgment for fraud upon the court in the SEC versus Reginald Middleton et al. April 11, 2025, the defendant's moving papers to be filed. May 2, 2025, the SEC's opposition, if any, to the motion to be filed, and May 9, 2025, the defendant's response, if any, to be filed by the defendants. The undersigned conferred with counsel for the SEC who consents to this briefing schedule. Now back to the article. So a year earlier, in March 2024, sanctions were placed on the SEC for, quote, abuse of power, end quote, for deceiving the court in the Debtbox case, provoking a scathing letter to Gary Gensler signed by Senators J.D. Vance, Tom Tillis, Bill Hagerty, Katie Boyd Britt, and Cynthia Loomis, which stated, quote, it is difficult to maintain confidence that other cases are not predicated upon dubious evidence, obfuscations, or outright misrepresentations, end quote. This is such a case to the nth degree, and to the detriment of America's position in the race to maintain its lead in the global economy. A temporary restraining order, or a TRO, was issued using questionable evidence and misrepresentations to freeze funds essential in mounting a defense, forcing a consent judgment where Middleton, quote, neither admitted or denied, end quote, the allegations against him. The claims made against Middleton were rebutted in his 423-page reply to the TRO filed on August 19, 2019. This reply, supported by almost 400 pages of evidence, was seemingly ignored by Tenreiro, Suthamanant, and Willinkin in issuing the memorandum in support of its application for preliminary injunction freezing assets on August 22, 2019, a mere 3 days later, claiming none of the charges were rebutted. Section 3, page 12, defendants have not rebutted the evidence of their fraud, manipulation, and unregistered offerings. The memorandum in support also failed to correct the record after expert witness Patrick Doody corrected his earlier declaration, which originally suggested dissipation of assets through a personal Kraken account. Quote, I understand now that the account is titled in the name of Veritaseum LLC, end quote, found on the last page of his second declaration, also filed on August 22, 2019. Quote, after learning of Middleton's transfer of funds, We took quick action to prevent the further dissipation of investor assets, end quote, said Mark P. Berger, director of the SEC's New York Regional Office, in the SEC's August 13, 2019 press release. The Commission's investigation and litigation was led by Jorge Tenreiro and Victor Suthamanant of the New York Regional Office, assisted by Roseanne Daniello, a staff accountant in the New York Regional Office, John O. Enright of the Cyber Unit, and IT forensic staff Ken Zavos and Olga Cruz Ortiz. The case is being supervised by Mark Berger, Lara Shalav Maraban, and John Enright, with litigation conducted by Jorge G. Tenreiro, Victor Suthamanant, and Karen Willinkin of the New York Regional Office. The smoking guns, fraud upon the court, allegations against the SEC. Number 1. Falsely claimed patents were not novel, stalled, and would never be granted, claiming Reggie misled investors about the status of Veritaseum's IP. A total of 7 patents have since been granted, with 3 in the US and 4 in Japan. These patents, titled, quote, Devices, Systems, and Methods for Facilitating Low Trust and Zero Trust Value Transfers, end quote, are foundational to DeFi, tokenized assets, NFTs, stablecoins, proof of stake, and proof of work. Coinbase filed an IPR challenge, IPR 2023-00751, in an attempt to invalidate these patents. The USPTO upheld the patents, denying the IPR challenge, and rejected an appeal based on, quote, lack of merit, further strengthening the validity of the patents. Number 2. Vader platform operability and functionality. A live demonstration was given before the SEC staff, and days later Reggie was told to shut it down. Tenreiro then claimed the platform was neither operational nor functional. Vita's channel on YouTube has videos to prove the functionality, but as shown in his affidavit, the owner was threatened by Tenreiro, quote, the line of questioning quickly turned aggressive, abusive, and threatening, end quote, and told to cease making videos, quote, through threats of multiple felony charges against me for supporting Mr. Middleton, testing his software, and publicizing the results through my YouTube channel, end quote. Number 3. Misrepresented ownership of Kraken corporate account as personal. Despite having served subpoenas on Kraken, Jorge Tenreiro misrepresented that the Kraken account belonged to Middleton personally, and further failed to correct the record after expert witness Patrick Doody corrected his earlier declaration, quote, I understand now that the account is titled in the name of Veritaseum LLC, end quote, found on the last page of his second declaration, also on the page 20 of the SEC RICO dossier. Note, Mark P. Berger said up here, after learning of the Middleton's transfer of funds, we took quick action to prevent the further dissipation of investor assets, said Mark P. Berger. So that's tying Mark P. Berger here, director of the SEC's New York Regional Office, to these claims here of dissipation of assets. Additionally, Kraken is not licensed to do business in New York, making it impossible for Reggie Middleton, a New York resident, to have a personal Kraken account, as found on Kraken's support page under Geographic Restrictions, an obvious oversight. Number 4. Misrepresentation of asset flow. Falsely alleged vast sums of money were flowing into Middleton's personal account, misleading the court about asset misappropriation of funds. This point becomes moot as the account is proven to be a corporate account, as evidenced in point number 3 above, and also in a 423-page reply to the TRO. And number 5, false allegation regarding agreements, alleging the defendants were merely negotiating deals with the Jamaican Stock Exchange, and here's a link to the Memorandum of Understanding, and the Nigerian Stock Exchange, and a link to the joint venture agreement, when signed agreements were already in place. The SEC's aggressive actions caused the cancellations of these agreements. Numerous FOIA requests have been submitted seeking communications between the SEC and the JSE, yielding little response. Number 6. Misrepresenting trading activity on Ether Delta as secretive manipulation, when in fact it was publicly announced prior as a liquidity and functionality test of the new platform. Also found on page 49 of Veritaseum's reply to the TRO, quote, testing Ether Delta as a method of distributing post-offering Veritas tokens. Anyone interested in buying Veri, please visit etherdelta.github.io and let me know. Number 7. Misrepresentation of CEO payments. Falsely misrepresented that 1.7 million in periodic payments to Middleton over 27 months, about 2.5 years, was dissipation of assets, misleading the court about CEO compensation, and this is detailed on page 55 of the SEC RICO dossier, linked here. Number 8. Nature of international payments. The SEC's TRO action misrepresented payments to overseas contractors as asset dissipation. Daniela would later correct her findings to show they were in fact payments to overseas contractors, and this is linked here. Nonetheless, the SEC continued to press ahead with their false narrative that the payments were part of an effort to hide assets outside U.S. jurisdiction to thwart judgment relief, which is clearly disingenuous characterization. SEC Memo of Law in further support of TRO, linked here. Number 9. Unethical conduct in no action letter request. Tenreiro involved himself unethically in a no action request, or NAL, request meeting, breaching the SEC's ethical separation as found in the bar complaint against Jorge Tenreiro. And number 10. Harassment of Veri token holders. Aggressively pursued Veri token holders to coerce them into giving evidence against Middleton despite them stating they were not victims of fraud. Victims of harassment have either come forth with notarized affidavits such as Lloyd Cupp, linked here, and John Doe, linked here, explicitly describing the SEC's coercive actions, and have expressed fears of retaliation due to their treatment after interaction with Mr. Tenreiro and Mr. Suthermanot. So this is wrapping up the article. Again, if you like my work, you can follow me here on X, Substack, YouTube, and Rumble, all at Sovereign Riz. And if you'd like to support my coffee addiction and keep my caffeine levels maxed out and help bring you more content like this, you can support me at coffee.com/sovereignriz, and that link is right here below. And I will catch you guys next time. Thanks again for all your support, guys. Appreciate it.